Book Beat is brought to you by CUNY Podcasts.
They really saw the ERA as fully embedded in this huge, larger project of bloodless revolution, to borrow Shirley Chisholm's words. And so it was you'd get a constitutional amendment, and you'd also get child care policy, and you'd also get Title IX, and it was related to Title VII, which prohibited sex discrimination in employment.
Welcome to CUNY Book Beat. I'm Rick Firstman. This month marks the 100th anniversary of the ratification of the 19th Amendment guaranteeing women the right to vote. It's also been 99 years since the beginning of a women's campaign demanding not just the right to vote, but full legal protection against discrimination on the basis of sex. The Equal Rights Amendment, commonly known as the ERA, is still not law, and some might even think it's a relic of another era. But it's been back in the news this year. In January, Virginia became the 38th state to ratify the ERA, the threshold needed for adoption of a constitutional amendment. But there's a big catch, which I'll be talking about with my guest. Julie Suk is Dean for Master's Programs and a Professor of Sociology at CUNY's Graduate Center. A graduate of Yale Law School, she's a scholar of comparative law and society who was a professor at Cardozo Law School before joining CUNY. In recent years, she's become a prominent expert on the renewed efforts to ratify the ERA and the ways in which it's had an overlooked impact on equality in spite of the resistance to its adoption as a constitutional amendment. Her new book is We the Women, The Unstoppable Mothers of the Equal Rights Amendment. It's a fascinating look at the dozens of women, some famous, others unsung warriors, who fought across generations to make full equality for women part of the Constitution. It's through their stories that she tells why the Equal Rights Amendment still matters. Professor Suk, welcome to CUNY Book Beat.
Thank you. Thanks for having me.
Sure. So the ERA, Equal Rights Amendment, has had a very long history, too long, you might say, and I'm sure you would say. This year marks the 100th anniversary of the passage of the 19th Amendment, guaranteeing women's right to vote. And it was followed by a movement to pass an Equal Rights Amendment to the Constitution. What was the genesis of the idea back then? What was the objective?
So once women got the right to vote, some of the suffragists, not all of them, but some of them believed that it was just the beginning, not the end. It had been a long struggle for the vote, but that they thought it was the beginning of a new era in which they could really struggle for women's freedom. And they believed that women needed equal rights in all domains, not only the right to vote. So they wanted to get rid of state laws that deprived married women of property rights that were still being enforced in some states. They wanted women to have equal access to jobs. They wanted laws that prohibited discrimination in the context of employment. And they wanted to find ways. I mean, I'm really talking about Crystal Eastman, who was a trailblazing lawyer in this era. They really wanted to find ways of making sure that women's economic independence could be possible even while they were bearing and raising children.
And we think of that as such a kind of a modern day progressive idea. People probably don't realize that how forward thinking women were all those years ago when it was such a different world, different country. So it took nearly 50 years before Congress passed the ERA in 1972, right? And it's been another 50 years in the battle for the ratification by the states. And I found it interesting to read that that most constitutions in the world are guarantee equality between women and men, and yet there's been so much resistance in the United States. Why do you think that is?
So I think that, and part of the reason I wrote this book and have been active in debates about the ERA today, I think one of the major issues is that the process that is set up by the Constitution itself in Article 5 of the Constitution makes the U.S. Constitution one of the most difficult constitutions in the world to amend. Under Article 5, you need 2/3 of both houses of Congress, and then you need 3/4 of state legislatures to ratify the amendment. And so the last time we actually had an amendment to the U.S. Constitution was 1992, so in the last century. And the amendment that we got in 1992 was actually written by James Madison himself, one of our founding fathers, in the late 18th century. So it's very rare that we get an amendment to the U.S. Constitution. And I think because of the tremendous consensus that's required to get a constitutional amendment, any kind of misinformation or controversy about the amendment's goals can really destroy the political possibility of getting the amendment. And that is actually something that happened with the ERA in the 1970s. In 1970 to 1972, the ERA was largely considered uncontroversial. It had a strong bipartisan support, and Republicans and Democrats supported it. It had been on the party platform since the 1940s of both major political parties, and the few women who were in Congress from both political parties, overall, they supported it as well. But I think once it was proposed to the states for ratification, there were a lot of campaigns that suggested that the ERA would do all kinds of things that it probably would not have done. And some people believe that it could end up meaning that there would be a strict rule prohibiting the different treatment of men and women under all circumstances. And that's something that Phyllis Schlafly really capitalized on in the Stop ERA movement that grew through the mid-1970s and has been dramatized now in the FX Hulu series, Mrs.America. They led people to believe that the law would never, ever be able to treat men and women differently. And people really feared that. So one of the major issues in the early 1970s was actually the military draft, because we were towards the end of our military involvement in Vietnam, which involved the draft of young men. And it was argued that the ERA would lead to women also being drafted. And it was a complicated issue because many of the most vocal proponents, the women in Congress who advocated for the ERA, women like Shirley Chisholm, who was the first African-American woman to be elected to Congress, Patsy Mink, who was the first Asian American woman to be elected to Congress, they took very strong stands that they believed the ERA would actually lead to the end of the draft. And the draft did actually end in 1973. They believed that everyone should serve their country, and if men and women both had to serve their country, it might cause the country to come to its senses about whether or not the draft was a good idea. And that piece of the history, of course, gets lost. But Phyllis Schlafly led everyone to believe that one thing that would definitely happen was that women would get drafted. She also argued that it would mean that you would have unisex bathrooms. And these are all things that the proponents of the ERA in Congress, they did not believe that the ERA would necessarily mean that women and men had to be treated the same under all circumstances. They thought that it meant that the law had to stop discriminating against women and enforcing mechanisms that kept women subordinate in American society. Sometimes that might mean you would have to treat women differently from men. That is, I don't think they were against any programs to advance women, affirmative action programs to advance women, for instance, or even maternity leaves. Some of those things are mentioned in the record of the ERA, and certainly Patsy Mink was one of the fiercest advocates and is now known as the mother of Title IX. Title IX was a statute that was passed around the same time that the ERA was adopted by Congress. As many people know, Title IX is really what led to equal resources for boys and girls in sports in many programs that are funded by the federal government, education programs. And Title IX is something that actually requires equal resources and equal participation. And sometimes that might mean that because there are inequalities in society, you take those inequalities that already exist into account. It might mean that men and women are sometimes treated differently, not based on stereotypes, but based on understandings of social disadvantage. But I think a lot of those complications got lost, and the movement against the ERA made people believe that it would just destroy any protections that women had, and that this would then destroy the American family and destroy American motherhood.
I'm wondering, how is the relevance and the potential impact, in sort of practical terms, how's that changed through the generations, especially in the decades since Congress passed it? Because there have been so many advances and changes in society, And it seems like, the ERA has a different context now.
So absolutely. Part of the reason the proponents of the ERA wanted it when they first got it to the floor of the House in 1970 was that before 1971, the Supreme Court had never said in any case that sex discrimination was unconstitutional. Women had been bringing cases for decades and losing them. They had been saying when a state discriminates against women, that is a violation of the Equal Protection Clause of the 14th Amendment. So women had been arguing that, but they had never won in any case arguing that before 1971. And the timing of the Supreme Court's first ever case in which they recognize sex discrimination as a constitutional problem under the 14th Amendment, it's a case called Reed versus Reed. The timing of that case is not a coincidence because when the Supreme Court decided Reed versus Reed, the House had already, by an overwhelming majority twice, once in 1970 and once in 1971, had already voted by a very overwhelming majority, over 90% of those voting, to pass the ERA. So I don't think it's a coincidence that the Supreme Court sort of starts to think about sex discrimination at precisely that moment. And of course, throughout the 1970s, the Supreme Court built on that case. The Supreme Court decided additional cases throughout the 70s that really established the principle that sex discrimination was a violation of the 14th Amendment, which we've, of course, had in the Constitution since the Civil War. And I think because of those developments, a lot of people say that we don't really need an ERA anymore. And because the Supreme Court has already done a lot of the work that could have been done by the ERA through this other legal tool, other legal avenue. And my thought about that is that I think that it's time to give credit where credit's due. I just don't think that the law would have changed without the movement for the ERA. The law changed because women, including Ruth Bader Ginsburg, who at the time was a lawyer and a law professor, she was heading up the Women's Rights Project, and she was writing the briefs that became the arguments the Supreme Court uses to justify its sex discrimination doctrine throughout the 1970s, right? And of course, Ginsburg in the early 70s was also doing a lot of writing explaining why we needed an Equal Rights Amendment. So if you think about that history, I think that not having an ERA is an undervaluing of the work women have already done to make equality of the sexes a constitutional principle. And so it's like making legitimate something that has been quietly lurking and developing.
So do you think that if it were to be adopted and added to the Constitution, would there be any practical impact day to day in the lives of women? And also, would it, sort of along the lines of what you've been just talking about, inform other cases that might come to the Supreme Court?
So absolutely. So two really important insights about this. One is that when the women in Congress proposed the ERA in the early 1970s, they were upset about the fact that the Supreme Court was not recognizing sex discrimination. And so they wanted an ERA not just to get the Supreme Court to change, but also to change the way we thought about enforcing the Constitution. What I mean is that they said when we get an ERA, it's not really going to be the courts that are going to be in the driver's seat here. It's going to be legislatures, Congress and state legislatures. So it's not like you get an ERA and then all of a sudden all these things become unconstitutional, right? That's one part of what the ERA would do. But the meat of the ERA for a lot of the proponents in Congress was it was going to create a foundation, a political nudge to Congress to pass additional laws that would make equality real. And some of those laws were already in the works. Title IX is one of them, and I mentioned that. And other laws that they were working on, which actually didn't come to fruition, but they thought of it as part and parcel of the project of women's equality, Comprehensive Child Development Act, which would have created federally funded child care centers and access to affordable childcare for all people, regardless of the means and of their means. So I think that these are the kinds of things they were really concerned with, having a constitutional amendment that would then trigger more legislative and policy change to make equality real. So it was a very different model of constitutional rights from the one we're used to, which involves having a right that then gets enforced by judges and only by judges. So that's one thing. The second thing is that I mentioned all of the changes that happened in the 1970s because of women's advocacy. So the Supreme Court did start to recognize sex discrimination as a constitutional problem. However, the Supreme Court stopped short of fully recognizing sex discrimination as a constitutional problem. So the Supreme Court decided cases in the mid-1970s that said that pregnancy discrimination was not an equal protection violation. So they allowed a state to have a temporary disability benefits program that covered every disabling condition except for pregnancy, targeted pregnancy and excluded it, right? And the Supreme Court says that's not sex discrimination and that's not a 14th Amendment violation. So if we're going to be faithful to that legislative history, I think that getting an ERA today would have to involve addressing any state policies that disadvantage pregnant women and mothers. That's been something of a blind spot in existing constitutional law. But it would also have an impact, and I think emboldening legislatures, both at the state and federal level, to pass new laws and policies that address these problems in a more fine-tuned way.
As you mentioned, so Virginia in January ratified the ERA and it became the 38th state, putting it over the top for the three-quarters of the states that are required for adding an amendment to the Constitution. But there's a big catch, which is the deadline for ratification expired like 40 years ago, almost, 1982. And also 5 states have, in those years, have rescinded their ratifications. So where does that leave it? Where does that leave the ERA?
So the deadline did expire in 1979, but a very important story that I tell in the book is that Congress actually voted to extend the deadline once. They only extended it to 1982, so that deadline has also obviously expired many decades ago. But the significance of Congress extending the deadline once should not be forgotten now, because the fact that Congress did extend the deadline once suggests that the Congress can actually take action today to extend the deadline again or to actually remove the deadline. Congress has that power. Congress's powers under Article 5 to govern the process of constitutional amendment has long been recognized by the Supreme Court. So, and in fact, Congress did take action in February of this year, just after Virginia's ratification, saying that they would recognize the ERA as part of the Constitution whenever ratified. Not within 7 years, but whenever ratified. So Congress, the House has actually voted by a majority in February of this year. The Senate has not acted on this, even though there is a bipartisan resolution now in the Senate with 48 sponsors. So because Congress has power over deadlines, they can set deadlines, they can change deadlines, they can remove deadlines. So I think if Congress acts now, if both chambers act to remove the deadline, I think that sort of fixes the lateness of both Virginia's ratification and Virginia's as well as the 2 other states that ratified in recent years, Nevada and Illinois. Now, as for rescissions, it's something that is a tricky issue because, of course, Article 5 of the Constitution doesn't say anything about rescissions. It says that amendments are valid when ratified by 3/4 of the states. The position that Congress has taken dating back to the 14th Amendment is that it's also something over which Congress has discretion. When the 14th Amendment was ratified after the Civil War, there were actually 2 states that tried to rescind their ratifications, but Congress said that they proclaimed the 14th Amendment ratified, ignoring those rescissions. And then fast forward to 2020, or just these past months, when Congress has been engaging in a debate about the status of the ERA deadline and the rescissions, in the House Judiciary Committee's report on removing the deadline, the Judiciary Committee makes pretty clear that they also think, and this is consistent with existing precedent on the issue, they also think that the question of rescissions is one for Congress to decide at the moment that the 38th ratification comes in. So when the 38th state ratifies, which has already happened, Congress has to decide, should we accept the rescissions or not?
So let's talk about We the Women. So your book is about what you describe in the subtitle as the unstoppable mothers of the Equal Rights Amendment. First, what led you to this book project?
So I had been writing, actually, about gender equality amendments in constitutions outside the United States. My background is as a legal scholar of comparative law, and particularly comparative constitutional law. And I was very interested in the fact that in my adult life, that is through the mid-90s and the early 2000s, many European countries adopted new gender equality amendments. And those amendments were precipitated by the fact that the legislatures had tried to adopt laws increasing women's representation in elected legislatures or even on corporate boards, and the courts were striking those down. And so they adopted these amendments saying that affirmative action, including gender quotas to help the underrepresented sex, are perfectly constitutional. So they wrote those amendments in the 90s and the early 2000s. So that set of developments got me thinking in a more critical way about what happened and learning the history of what happened with the ERA in the United States, because one of the things that many people say about the ERA is that we are an outlier in the world in not having a guarantee of equality or equal rights for women in the Constitution. So I wanted to study that, and I wrote a series of articles in the academic literature, in the law review literature, about situating our ERA history and trajectory in the context of global constitutional norms. But I wanted to write this book. This book is not necessarily intended for legal scholars or lawyers or even scholars in other disciplines, although certainly they will learn things that they did not know from reading the book. I intended the book to be also for citizens, for general readers, because I think it's important to understand the process by which the ERA was proposed, why it was proposed, how close it's come to becoming an amendment, and why it's fallen short. So what I do in the book is I really look at the legislative history. It's a narrated legislative history. So the primary place in which everything happens in the book is in Congress. That is, what were the lawmakers thinking? How were they criticizing the existing legal context? Why did they think that the ERA would make a difference? What were women thinking in 2017, 2018, and 2020 when Nevada, Illinois, and Virginia resurrected the ERA? And these things are important because we need to have a popular democratic understanding of what a constitutional amendment means. And the ERA is actually very unique in that it is a transgenerationally generated amendment. It was introduced in 1923. It was adopted by Congress in 1972. Ratification was arguably completed in 2020. Three completely different historical moments. At each moment, the people who started it in the last significant moment are dead, and there are new generations that take up the battle, and the social context has changed significantly since the last significant moment. And I think this poses also a very interesting problem, because if we get an amendment now that has that kind of trajectory, how do we interpret it? How are judges going to interpret it? How is the legislature going to interpret it when it adopts laws to give it meaning? And I think that in order to answer that question, we need to have a readable and understandable history of what was intended and what was struggled for at each of these moments.
Right. Well, there's a great cast of characters, which you very neatly arranged with chapter titles: the pioneers, instigators, globalizers, all the way to the latter-day resurrectors, and now the history makers. So out of all of these women across these this 100 years, talk about one or two of your favorite mothers of the ERA.
Oh, wow.
If you can pick
okay, yeah. So I
sort of
don't,
the opposite of picking your favorite child. But.
Right. So I don't know if I'm going to call them my favorites, but I would like to highlight a couple of things. So, and I think I'd like to focus perhaps on the ones that are forgotten. At one point in this project, I was going to call the book The Forgotten Mothers of the Equal Rights Amendment, because I think that in our popular imagination, the one name that a lot of people associate with the ERA is Phyllis Schlafly, and she was someone who actually stopped the ERA. So in the 1970s, Martha Griffiths, Patsy Mink, Shirley Chisholm, these were women in the House of Representatives. There were only 10 women in the House of Representatives in 1970 when a lot of the momentum gets started. And so Martha Griffiths, she was a congresswoman, a Democratic congresswoman from Michigan. And what was really amazing about what she did in 1970 was she got the ERA to the floor of the House of Representatives. And it was actually a very difficult thing to do because the ERA was introduced in 1923, and there were hearings throughout the 20s, 30s, 40s, but it actually doesn't get a floor vote in the Senate until 1950 and 1953, and the Senate passes it in 1950 and 53, but nothing happens in the House. And there's a reason nothing is happening in the House throughout the 1950s and 1960s. And that is that the chair of the House Judiciary Committee, a guy named Emanuel Seller, just blocks it. Doesn't really want it to get out to the floor, doesn't support it, has never been a fan. He was actually in Congress in 1923 when it was introduced. And so if the House Judiciary Committee is not going to send it to the floor, it doesn't matter if most of the people in the House actually support the ERA. If it doesn't get debated and voted on, you're not going to have an amendment. So what Martha Griffiths does in the summer of 1970, 50 years ago now, is she does a discharge petition. It's a little-known parliamentary device by which if you could get half of the House to sign a petition, then you can wrest a proposal out of the control of the committee that has jurisdiction over it. So she gets all those signatures, half of the House, to sign her petition. It gets a debate on the floor, even if the House Judiciary Committee doesn't send it to the floor. And that's what she does in 1970. And once it gets to the floor in August 1970, and everyone's very conscious of the fact that it's the 50-year anniversary of the 19th Amendment, there's overwhelming support for the ERA. I think 96% of those voting support the ERA. But when it goes to the Senate in 1970, it essentially dies. And then the ERA was reintroduced again by Martha Griffiths in 1971. And that's the session of Congress from 1971 to 72 that actually adopts it by 2/3 majority. But I think the fact that there were so few women in Congress, but actually growing support for women's rights, such that a discharge petition had to be used, and then it was successful, and overwhelmingly successful, at least in the House. I think that's a very important part of the story that is not necessarily known. And so she is someone who's forgotten and important that I hope readers will engage with, right? And then Patsy Mink and Shirley Chisholm, they gave really amazing speeches on the floor, both in 1970 and 1971, and in their testimonies to Congress. And as I mentioned earlier, they really were the first women of color who were elected to Congress. Patsy Mink in 1964 and Shirley Chisholm in 1968. So they get elected and they advocate for the ERA. And what was really amazing about their advocacy was that they weren't single-issue people. They really saw the ERA as fully embedded in this huge, larger project of bloodless revolution, to borrow Shirley Chisholm's words. And so you'd get a constitutional amendment, and you'd also get child care policy, and you'd also get Title IX, and it was related to Title VII, which prohibited sex discrimination in employment. And they had a lot of other bills that would have strengthened equal pay laws, for example. So it was this large legislative agenda with ERA as being kind of the constitutional anchor and moral core, if you will, right? And I think it's the contributions of these women are important for two reasons. One, so that people know that it was not just a white women's initiative, that the ERA has always been, at least since this moment, something on which women of color have taken a leadership role. And that fact is, there's a through line, because if you look at the women who have been sponsoring the ERA resolutions in the states that ratified in recent years, Nevada, Illinois, and Virginia, African American women have actually played a very important and leading role in doing these late ratifications. And so I think that's also very important. And so while we're on the subject of favorite characters from the book, I want to mention Pat Spearman, who is a Nevada senator, who really instigated the resurrection of the ERA in the Nevada Senate in 2017. And then in Illinois, there were so many women who were involved, and in Illinois, the ratification in 2018 was very engaged with other developments that were going on in the state around the Me Too movement. There had been legislative task forces formed in Illinois to address sexual harassment issues within the legislature itself, and a women's caucus was formed, and some of the women who were involved in those efforts were also leaders on the ERA resolution. Someone who was very vocal on the floor votes was Juliana Stratton, an African-American woman who went on to become the lieutenant governor of Illinois. And then finally in Virginia, so many women and women of color who took a leading role in the House of Delegates and in the Senate. So Jennifer McClellan in the Senate. And what's really outstanding about Jennifer McClellan in the Virginia Senate is that she was also the first woman in the Virginia House of Delegates. Before she was a senator, she was actually in the House of Delegates, and she was the first woman to give birth while in office. She was pregnant and gave birth while in office. And she loves to tell this story about how when she was pregnant, a lot of people said to her, "Well, you're not going to run for re-election now, are you?" They just assumed that she'd be retiring from lawmaking because she was pregnant. And her response was, she pointed to a male colleague. She said, well, his wife is pregnant, so he's going to be a father. Why aren't you asking him the same question? And so that's the story that's in my book. And I think it's important, not just because, it proves that women, it's a story about women's growing access to power and exercise of power, as well as its connection then to what happens at a legal and policy level. And in Virginia, Jennifer McClellan has also sponsored, in the same legislative session that involved ERA ratification this year, 2020, she sponsored the Pregnant Worker Fairness Act, which is a law in Virginia, and many states now have such laws that not only prohibit pregnancy discrimination, but actually require employers to accommodate the needs of pregnant workers and not fire them because they need certain accommodations. And that's been very important to this story as well. The story of unstoppable mothers is not just the mothers of the ERA, like the founding mothers who authored the laws, but also the mothers who are actually most likely to benefit from the laws that we're likely to see change as a result of the ERA.
Well, they're an amazing sisterhood, motherhood and sisterhood across the decades. The book is We the Women, The Unstoppable Mothers of the Equal Rights Amendment. It's out this week from Skyhorse Publishing. Julie Suk, congratulations, and thanks very much for talking with me about it on CUNY Book Beat.
Thank you so much for having me. I've really enjoyed it.
For more Book Beat, visit CUNY Podcasts at cuny.edu/podcasts.